Neil appears on behalf of the respondent, Mr. Streeton here intervening pursuant to the order of Lord Justice Holgate on behalf of the Secretary of State.
Yes. Well, thank you all for your helpful written material. We've obviously had a good chance to look at that and to look at the leading authorities to which you've all referred.
And well, that's very helpful as an indication. In terms of the pages in the bundle which deal with the factual material, of course, we have the benefit of the judge's judgment where he set out in as full a detail as we need for my purposes, certainly, the chronology. And so I intend to follow the order that the judge laid out in terms of the chronology, but the court will perhaps have had an opportunity to look at some of the materials that were supporting the planning application that Mr. Moran actually made, including the series of drawings, the planning support statement, and the various reports that were...
Yes, well, I can see that over a period of a year or so he went to some lengths to put in a proper application.
Yes, and the judge made his observations about the nature of that application. And so in terms of the grounds of appeal, as my lords know, the first ground is essentially a Padfield ground. The second ground for which I need the permission of this court is to consider whether or not, in relation to what I will call a prospective application for planning permission, Section 70C has any application at all.
Yes.
Whatever the purposes of that provision may be under ground one. And then thirdly, as my lords know, we made a sequence of criticisms of the basis upon which the Section 70C decision was actually made.
So on the merits,
on the merits, but as we would say, attacking legitimate.
Well, would it be convenient to deal with ground two, putting ourselves in a world in which you had permission, and then once we've heard all about it, we'll decide whether you should have got it?
My lord, I'm grateful. I'll proceed on that basis. And so in terms of the permission order that was granted, my lords will have seen that and the supporting reasons for it in relation to the real prospect that Lord Justice Stuart Smith found that we had in relation to grounds 1 and 3, but also the broader point he made about what the implications may be of the respondent's case, and indeed the Secretary of State's case, if those cases are correct. And he used the colourful phrase, as it were, of being in planning aspect. But we're really, if one looks at the facts of this case, is perhaps an interesting case to consider from that perspective, because of course the enforcement notice in this case is of some vintage now, and we are, as planners would say, quite a long way down the track in terms of policy having changed, circumstance on the ground having changed, and that sort of consideration. And so it's against that kind of backdrop that this court is being invited to consider whether there is essentially an indefinite bar in relation to fresh planning applications being made, whether they relate to retrospective.
But it's not an indefinite bar, is it? It's provides the local authority with control over whether the circumstances are such that, as an exercise of its discretion, the application should be considered, the merits of the application should be considered. So, whilst it was described as being in aspic, that doesn't prevent the morsel being consumed in due course.
No, an authority could say yes.
Yeah.
But plainly exercising their discretion. But the point that's made in the authorities, as my lord knows, is that in relation to that discretion, it is a wide discretion. The question may be whether it's an unfettered discretion, as referred to in cases like Padfield, or whether the nature of the circumstances surrounding the statute and the statutory provisions themselves mean that there is an identified purpose which is capable of restricting what is otherwise unrestricted language, conferring a wide discretion. And so that's the essence of the appellant's case under ground 1, that we say when you look at Section 70C, when you look at the surrounding sections, when you look at the nature of the legislative scheme as a whole, and you look at the way that the enforcement provisions are designed to operate, all of that speaks to a conclusion where, in fact, the Wingrove case correctly identifies the real mischief here. And the real mischief is the issue of delay that is caused by the ability, which happens once an enforcement notice is served, to otherwise potentially appeal under the enforcement notice, and at the same time, or slightly later, put in a retrospective application for planning permission, so that there is a requirement on the local planning authority to determine that, and then a further potential right of appeal from that determination, which, if it's made, would quite often be linked up with the enforcement appeal, thus occasioning significant delay whilst the unauthorised development remains on the land.
Could I just, before you get fully underway, mention just a point of administration, which is that for a particular reason, it would be very helpful if we were able to conclude the hearing of the argument on the appeal by 4 o'clock this afternoon. I'm not suggesting that you have to keep going till 4 o'clock if you've satisfactorily dealt with it beforehand, but I hope that the unspoken understandings that pass between council on these occasions can operate in order to achieve that.
I'm sure we can, and our provisional timetable, I think, accommodates that time.
Good. Well, you're not under any pressure of time. If we can't make 4 o'clock, then that's too bad. But it would be very helpful if we could. Can I just ask one question before you develop your argument? Are you saying that that the section in question 70C simply doesn't apply to this?
Yes, that's ground 2.
Right. So you're saying that it's not just that it applies to it, but it shouldn't be used.
Correct.
For this reason and that reason. It's that actually the situation that your client was in on your argument falls outside it altogether.
Yes.
And that's ground 2 because of retrospective.
Yes.
Right. In some ways, is that not the first question? Before we decide, because if you're right about that, then that's an end, isn't it?
Well, my lord, it may well logically be the first question to take. There is, I would submit, quite a close connection between the approach to ground 1 and Padfield, because that involves a full understanding of the statutory scheme, what it was endeavouring to.
Yes, but from my simplistic point of view, there's a difference between saying, well, this statutory provision just simply doesn't, local planning authorities and developers and individuals wishing to use land in a particular way, they needn't trouble themselves because we're not in 70C territory. So we needn't worry about what it's there for because it doesn't apply. Isn't the question of does this apply come before what's it for and how do you use it?
My lord, I accept that logically.
By all means, if you prefer to structure your submissions in a different way, but speaking myself, that's the question that I need to know the answer to before we consider what it's for.
Yes.
Because if it doesn't apply, then it doesn't matter what it's for.
No, my lord, can I have those observations in the front of my mind as I work my way through my submission?
Well, I'll now get out of your way.
Great. So, my lord, in terms of a roadmap, first of all, just to look at some elements of the judgment, bearing in mind the court will be fully familiar with the terms of the judgment, then to turn to the statutory framework, to look at some of the key cases that the court has identified it's had an opportunity to consider, and then to turn to my submissions, including the criticisms that we make of the officer report within that subheading. So that is the roadmap. But as the court knows, this is the first time that this court has to consider the scope of Section 70C, and in particular, and as the court knows, we say this is critical, it's the first time that the court has had to consider this provision in the context where there is no current breach of planning control on the land. And so if I turn, first of all, to the judge's judgment in the core bundle, my lords, we've got an interesting core bundle in that the electronic pagination doesn't tie up to the manuscript pagination, and so apologies for that. But the judge's judgment starts at page 42 of the core bundle, which is Adobe page 102 for those who are using the electronic version. So, well, if we move...
Did you say 42?
But 42 in...
Well, I think I'm used to working on a different page. 60 pages I've never encountered before.
No, 60 pages is different, but the reason is that we've got some very interesting Roman numerals early on in the core bundle.
Yes, all right. Well, we'll manage. So if you wouldn't mind when you're going through it to also refer to paragraph numbers.
Yes.
As I can then find my way.
So, my lord, then starting on page 43, paragraph 4, the level of agreement about the potential purposes of section 70C was identified by the judge, and of course an essential part of the difference between myself and my learned friend below was whether there was what the judge would have described, I think, as a narrow approach to section 70C, or whether there was a broader approach to the purpose of section 70C, which accorded with the purposes identified by Mr. Justice Lewis, as he then was, in the O'Brien case. And then the judge continues to make the point, which again we say provides interesting context for this case, but also important to assessing how section 70C was exercised here. This is one of those cases where the merits have never actually been determined by the council in the context of a full planning application. They would say, correctly, that there's been a measure of consideration in relation to whether or not it was expedient to take enforcement action, and there's been a measure of consideration in relation to whether or not they should take direct action. But neither of those are directly equivalent to the consideration that occurs on a full planning application being made and considered. And so that is what has never happened in this case. And so to the extent that the authorities refer to bites of the cherry, we have never had that substantive bite of the cherry. Now, the reason why that occurred in this case, as the court knows, is because a former individual who was occupying the land but didn't have a sufficient interest attempted to appeal, but Pins turned that appeal away. That was back a long time ago when, or shortly after, the enforcement notice had been served. And so that is an important part of the factual matrix in this case. Next, can I go to paragraph 29 of the judge's judgment on page 47 of the Bible, just to remark, as the judge did.
Sorry, can I have the paragraph again, please?
Yes, 29.
29, thank you.
Over a year later.
Yes, thank you.
So, as the judge observed, in fact, in this case, by the time the planning application had been made, there was no remaining breach of planning control on the land for over a year, in fact, in the order of 18 months on the timings that we can see.
Why does that matter?
My lord, the reason that we say that's crucial is because planning enforcement is concerned with remedy. It's concerned with...
Still, you say there's no breach of planning control.
Yes.
Doesn't mean there's no planning control.
Absolutely.
I mean, there is planning control, and
yes.
It continued, including on the 8th of September.
Yes, and what the enforcement regime allows to happen is that if there is a resumption of the breach after it has been removed from the site, then there is the risk of criminal sanction under section 181.
I don't understand what the relevance of this at all, because that would mean that the planning status of the land depended upon whether people chose to be compliant or disobedient.
Not the planning status of the land, but the ability to have a planning application entertained by the local planning authority.
Well, I'm happy that you put it that way. Why should that depend in any way as to whether people are compliant or disobedient?
Because the purpose of section 70C and the purpose of the enforcement provisions more generally is to secure the end of the breach.
So an enforcement notice somehow becomes lesser because somebody complies with it?
No, the effect of section 70C becomes lesser because one can test it this way.
Right, so, but that's what I understand your submission to be, that the effect of section 70C becomes lesser because somebody has decided to comply with an enforcement notice.
Yes.
All right, well, That's sufficient.
for two essential reasons. Firstly, the overarching nature of the scheme in enforcement terms is to seek remedy of the breach of planning control. And so that objective, that statutory objective, has been met in these circumstances. The second point, closely related to that, is that there is only one mechanism by which an individual in Mr. Moran's circumstances can seek to regularise, assuming that the planning merits are in his favour, because if they're not, the planning application will be refused anyway. There's only one way he can regularise the position, and that's to make his application for planning permission. And that is why, when we look at the statutory scheme, section 180 of the scheme has a clear carve-out in relation to later planning permission that is granted after an enforcement notice is served. So the statutory scheme presupposes that part of the reaction to an individual who is served with an enforcement notice may be to appeal under ground A, or it may be for a successor in title at a later point in time to come along with a proposal that overlaps to some degree with the enforcement notice that has been served, to make their application for planning permission. And to the extent that that is successful under section 180, then the enforcement notice will cease to have effect to that extent. So the statutory scheme, it specifically envisages that there will be further planning applications in response to an enforcement notice if someone thinks that planning circumstances have changed on the ground, or the planning policy has changed, either at a local level or national policy has changed with the production of the planning policy for travellers in 2015 and so on. And so the statutory scheme makes that provision, and it does that also making provision for the circumstances of, well, what is to happen if the breach of planning control resumes? So the code covers that eventuality as well, and that's what it does in section 181. So we say when you look at all of these provisions together, and when you bear in mind that the two reasons essentially why an enforcement notice will be served, assuming it's expedient to do so, is either to remedy the breach of planning control or to remedy injury to amenity. Those are the two reasons why an enforcement notice might be served, and the steps that are required to be set out in the enforcement notice will follow one or two, well, one of either of those tracks. When one bears that in mind, what that serves to demonstrate, we say, is the essentially remedial nature of the enforcement notice regime. Of course, it has additional teeth to it in the sense that there are criminal offences that are created once an enforcement notice comes into force, if there is a failure to comply at that stage. But none of that detracts, and indeed might be said to enhance the point, because there is potential criminal liability, that if the only focus for someone altering that position, and take the case where the planning policy has actually shifted, and it's shifted in a demonstrable way, so that it is clear that there is at least a realistic prospect of planning permission being granted. In those circumstances, why should it be that Section 70C operates subject only to the control of Wednesbury irrationality or other public law challenges to shut out an individual from making a prospective planning application? I say that that is to be treated entirely differently, both for the purposes point under Panfield and for how far Section 70C extends from the case where there is a continuing breach of planning control. Part of the reason for that is because what Section 70C is directed towards is the idea, and one can see this, as my lords will have seen from the speeches that were made in Parliament. There's a question about pepper and heart, but just in terms of identifying context of mischief, you can take from what was said in Parliament, and you can take from the impact assessment, But what these provisions are concerned with, what motivated the legislation to bring them forward, was to address issues that were seen to be important about the level of delay in enforcement proceedings being effective when there was unauthorised development on the land. So that is the essence of why the provisions were brought forward. My Lord, apologies for being sidetracked from where I was. It happens in this court from time to time. But I was looking at certain paragraphs of the judge's judgment. Can we go back, please, to paragraph 35? And that is page 48. And here the judge is identifying Mr. Harris, who was taken to be the author of the reports. He signed off on the local authority's report. Harris then stated the criteria for the exercise of the discretion, and the judge records what he said in the report. Section 70C was introduced to ensure that the time taken to determine a planning application, including appeals, should not prevent effective enforcement. Well, we agree, and we would submit that that is a pithy description of what is intended. The problem is, when we get on to ground 3 later on, that the report at no stage answers how that point is to be put in the balance in circumstances where the local planning authority accepted that there was no continuing breach of planning control. And so there was simply no question on the facts as they found them to be of there being a delay to effective enforcement taking place. At paragraphs 51 and 52, the judge, this is page 50, the judge was recording the submissions of the parties, and in particular my submission about what Wingrove identified the purpose as being. And my Lord, that's the case that I advance now in those terms as they're set out in paragraph 51 and 52. When we look at the alternative that the judge was attracted by, Mr. Neal's submissions on page 51, paragraph 57, middle of that paragraph, more widely, it's to remove from applicants and their successor entitled the opportunity to have the planning merits determined more than once. So that's going directly to the wording of the statute, and that is where Mr. Justice Lewis, as he then was, took the purpose from the wording of the statute. I invite this court to approach it in a different way, to see that the wording of section 70C is the mechanics, is the mechanism for how the mischief is to be dealt with. What is necessary, the appropriate steps we say, are to identify the statutory mischief, what it is that this provision was dealing with, and then what follows from identifying with precision, and when the court goes back to Benyon, you'll see that when it deals with the mischief, the point is made that it is important to try and identify with precision what the particular mischief is that the statutory provision is directed at. And when one does that exercise, the purpose reveals itself, because the purpose is to address the mischief, the precise mischief that is found. And in this case, the mischief is not the idea that someone might make more than one application in certain circumstances. The mischief is that there will be delay to effective enforcement in circumstances where there is a breach of planning control, i.e. unauthorised development.
Why should it? In this case, from memory, the judge found that there had been 8 exercises of the 70C power, which I presume means that there had been 8 applications.
Yes.
Which they'd refused to determine. Why is it not a mischief that people keep applying for planning permission that has that is which, if allowed, would be a breach of an enforcement notice.
Yes.
Why is that not a mischief?
It's not necessary to have that as an additional.
But isn't it a mischief? I mean, if you've got 30 people living on the same piece of land, why on earth should planning authorities have to deal with 30 applications when these applications are passed from hand to hand and made and remade? I mean, is that not a mischief?
My lord identified one of the issues that the cases were plainly endeavouring to deal with, and that's the idea that, of course, it wouldn't be enough simply to stop an applicant from making an application because, my lord indicates, you'd simply invite another person who happened to be occupied.
I don't think you even need to occupy the land to make an application, do you?
It would be normal.
Well, I know it might be normal.
Have an interest in that.
I know it might be normal, but I could have applied. I mean, anybody can apply for planning permission. So what's to? I mean, why is that not a mischief in relation to the planning system?
The system, Section 70C, potentially would be open to abuse.
Yeah, so it's not just in relation to the determination of applications. It's the burden of having to deal with applications which are asking for the same thing again and again, isn't it? Isn't that part of the whole picture?
My lord, no. That is part of the picture, and it may be one of the effects, but it's not the mischief. And the way that you test that, I would invite the court to consider, is on the Secretary of State's argument. This is what the Secretary of State says. One, there is the wider provision, the wider purpose, as identified by Mr. Neal before the judge. But also, in addition to that, there is the issue about resource allocation, about whether or not a disproportionate level of local authority resourcing is being used. That's
what I'm putting to you.
Yeah, indeed. But if that's right, if that is part of the mischief by itself, then in relation to the reasonable exercise of discretion under Section 70C, a local planning authority will always be able to satisfy it, and the perverse effect will arise that it will be easier to satisfy in the more deserving cases. Because, take this case, where in fact, after the breach of planning control ceases, and a far more coherent, on any view, planning application is put forward with professional evidence, as my lord indicated, put together over the course of about a year, that is precisely the kind of application that, if it's going to be determined on its merits, will need the authority to invest resource into it, because they may need to speak to outside consultants about issues like biodiversity. They may need to look in detail about criticisms that are made about their levels of local need, for example. And so if the Secretary of State's answer is a sufficient answer and is part of the mischief, then it will almost always, I would submit, be open to a local authority to reasonably say, we can use Section 70C because this is one of the purposes that it's directed towards. And that will allow the creation of planning aspect. The risk is that land becomes sterilised for no sufficient planning reason.
Well, isn't there sufficient planning reason that there's an enforcement notice over it? I mean, one of the features that of the argument that may be deployed against you is your client has interests, and you've very ably presented those to the court, interest in having a decision, a redetermination on the merits that was not available to him prior. But the public also have an interest, don't they, in understanding that what is on the planning register is respected, and respected by Section 70C, such that it isn't that there would never be a change of use of the land next door, but there is an additional restraint on that use changing when an enforcement notice, which would have been on the planning register, when an enforcement notice is in place. So isn't that the mischief or part of the mischief we're concerned about, ensuring that the interests of the wider public are protected, where in the public interest an enforcement notice is in force, however it may be enforced, but is in force in respect of a particular planning unit?
Well, if I deal with the point about resources first of all, do come back to that observation that if it's right that this is part of the mischief and therefore the purpose is addressing that mischief, then in those circumstances it will be straightforward for authorities simply for that reason alone, and it will be perverse, I say.
Well, then you've got ground three, haven't you? If the local authority, if the circumstances have changed such that the local authority cannot reasonably form the view that, for instance, a reasonable planning inspector, or there is a reasonable prospect of a planning inspector upholding an appeal, then it would seem strange that they would deploy Section 70C to the point that it may well be an error of public law to do so. But that's not the point I'm putting to you. The point I'm putting to you is, where is the interest of the wider public in respect of this argument? And as I say, it may be a point taken against you that actually the mischief here, it ranges beyond what was in the other authorities that we're going to come to, but actually engages the public interest in ensuring that, for instance, if I buy a parcel of land next to land where there is an enforcement notice in place, I can rely upon the enforcement notice.
I will come to that point immediately. Perhaps perverse is an inapposite choice of word, but absurd in terms of what the statutory consequences would be, leaving aside the local authority's decision-making process, which is always potentially susceptible to those criticisms of public law. But if the scheme itself says it is a sufficient statutory purpose that the authority can take into account the fact that there will be a resource implication for continuing to determine a fresh planning application, then that will facilitate, consistent with the statutory purpose, the operation of Section 70C in a very wide range of situations beyond those that we say Parliament intended. And part of the reason why I say that is because the mischief that my Lord is identifying is, I would respectfully submit, a much broader mischief than the actual concern, which was to do with the delay in enforcement when unauthorised development remains. But moreover, there are other parts of the statutory scheme that directly address the issue of resource allocation, and you can see those in Section 70A in particular. And so, as my lords will know, what Section 70A is often referred to as being used for is preventing repeat applications where the impact of those applications would be to wear down the local authority. So there is that limitation on making similar applications within a period of 2 years. But as my lord knows, in fact, the language that's used there is a lot less exacting of a planning applicant, because as long as there is some material difference, I paraphrase, but my lord will understand the point, is as long as there is some material difference in the second application that is coming forward, then the local planning authority is obliged to consider it. And after a period of 2 years, even if there isn't a material difference, they would still be obliged to entertain it. So the way that the resource implication is dealt with within this group of sections, which broadly speaking might be taken to be addressing different kinds of potential abuse of the planning system. So in Section 70A, we have the ability to wear down through repeated applications and achieve a result that you shouldn't be achieving. So that's the nature of the abuse. Section 70B is to deal with the circumstances where there is twin track, mostly, between appeal provisions, appeal submissions, and further planning applications. Section 70D, a relatively new introduction, I think my learned friend Mr. Streeton is going to draw your attention to. That's dealing with a kind of abuse that is far more recently recognised on the developer side, as it were, where planning permissions are not being brought forward at the pace, at any reasonable pace. That's where that provision is directed. And that leaves Section 70C. Section 70C is different in that it is the one that deals expressly with the enforcement context. And it occurs at a later point in time. It's introduced into the statutory scheme at a later point in time, because we have Section 70A and Section 70B in substantially the form they're in now as a result of the 2004 Act. And then we have the 2011 Act producing Section 70C and some other provisions that are referred to in the impact assessment, which are, again, broadly speaking, directed to kinds of abuse of the planning system.
Is it your submission that 70C only applies if there is continuing breach of an enforcement notice?
Yes. Because otherwise there are sufficient protections deliberately codified in the statutory scheme, and they are found in, amongst other places, Section 181, where if the breach resumes, we know what the consequences of that may be, and in relation to Section 78, where the point about resources and whether or not for that reason alone, for the inappropriate use of local authority resources, they can say no to a planning application, is also addressed, and it's addressed in very different language compared to Section 70C. Now, when you pull all of those things together with the idea...
That's your... Oh, sorry, I'm sorry to speak over you, but that's your... If I'm rightly understanding, that's really your core submission, that you can pin it down in that way. So effectively, Section 70C it can come on, it can go off, depending upon whether the occupier, let's call them, decides to continue with the prohibited use or not.
Yes.
So they can depart, whereupon 70C is not available. They can depart and apply. Section 70C not available. They can then go back in. It is available. They can depart. I mean, it all depends, does it, on this analysis as to whether they comply with the enforcement notice or not?
It depends on whether or not there has been compliance with the enforcement notice. Yes, because...
it must follow from your core submission that it is a power that is only available when somebody is in default.
The ability to use Section 70C, yes.
Yes, yeah, that's very clear.
Yes. And my Lord has some of the core reasons why I say that. I was inviting the court also to consider the nature of the town and country planning legislation more broadly. As a point of statutory construction, looking at long titles will provide some guidance as to what is intended. The Town and Country Planning Act is concerned with, amongst other things, control of land. That's in the long title of the first act, and it now finds itself, albeit as a heading, in Part 3 of the 1990 Act. So that is the broad heading under which we address this issue. Then we look at the more narrow range of provisions in Section 70, A, B, C, as we've been doing, and see what the language of those provisions tells us about the mischief they were trying to identify. And it's because of those provisions that I say that the correct approach to Section 70C is to say that it was dealing with a very specific mischief, which is not the mischief that Section 70A is directed towards. And the only consequence of the local planning authority not being able to rely on Section 70C in these circumstances is that they will be obliged to entertain a validly made planning application and determine it. That's the extent of the additional obligation that the local authority is under. It, of course, doesn't say anything about whether or not they will say yes or no with conditions at the end of the day. But what it does mean is that someone, if we take an example of someone where there has been a breach of planning control, they buy the land knowing that, but they take every step that is required in order to remove that breach, and then approach the local planning authority in those circumstances, having expended money to do it. That's another alternative factor situation that might arise. And all that our construction requires is that the local planning authority in those circumstances, and let's say that there's been no breach for 18 months, has to entertain the application. And we say that when one looks at it in that way, the nature of the change is one that's very easy to understand in terms of the statutory purpose. Because, as I have said, when we go to the enforcement provisions themselves, it is a scheme based on remediation. And I say to the court that is central, because what that means is that when the steps have been taken, full compliance, not partial compliance, but full compliance with all of the requirements of the enforcement notice, at that stage, the object of the enforcement notice is secured, because there is no continuing breach, and the further object of the enforcement notice of being effective against a potential recurrence has also been achieved because it remains in force as a result of Section 181. So it's not analogous with the situation where there is an initial appeal under Ground A, and the effect of that appeal is to stop the enforcement notice coming into force. That was an important part of the reasoning we submit behind why these provisions were introduced. It was the idea, and you can take this from the earliest statutes, because as my lords will have seen, even as early as the Town and Country Planning Act 1947, the ability to appeal, and we have this in the authorities bundle, hopefully all of the pagination does.
Can I put the judgment away then?
My lord, yes. Just behind tab 1, we have two of the sections from the 1947 Act, simply there to demonstrate that from the first codification of the Act, enforcement notices were there, provision was made for them, provision was made for certain routes of appeal. You can see on page 5 of the bundle under the provisos, one of them being an application for permission for retention on the land, and the provisions relating to the notice not coming into effect until those potential challenges have been determined was in the Act at this stage. So it has always been a fundamental part of the town and country planning legislation that an individual who's affected by an enforcement notice should be able to appeal it, and in fact, until that appeal is determined, the notice should not be enforced. Now, it is that power that remains in the 1990 Act which has led to the abuses occurring, because the advantage in people who are continuing to commit breaches of planning control is to try and delay, string that process out. And we say that that is the mischief that's being identified in the cases that the court has looked at. Just before I turn to those cases, can I invite consideration of what the word retrospective means in this context, because it's been the subject of some debate, and what we say retrospective means is that it's dealing with the retention. A retrospective application is one that seeks to deal with the retention of some element, perhaps not all of it, but some element of unauthorised development. And simply for my Lord's note at this stage, we say you can take that from a number of the authorities, and rather than turn them up for these purposes, I simply give a list of references. Firstly, in relation to Wingrove, that's at tab 26 of the authorities bundle, starting at page 264. And as the court will recall, that was concerned with the retention of 2 residential units inhabitants that have been present on the land for a period of about 5 years by the time the matter was before the court. And if one were to look at page 267, paragraph 11, page 268, paragraph 15, page 270, paragraph 21, and page 272, paragraph 30, you would see there the term retrospective being used in that sense in how the judge applies it, how the local planning authority describes it, how Professor Purdue uses the label, and as we know, the key discussion in Wingrove is paragraphs 30 to 32, and so it's within that key discussion as well. Similar sentiments can be located in 17 De Vere Gardens, in Banghard, and in Chesterton, and I will very quickly give the references and then move on. In 17 De Vere Gardens, it's page 298, paragraph 1, 302, 23, 306, 34, 309, 40. In Banghard, the holding, first page of the report, 313, and then 318, paragraph 14. And in Chesterton, 328, paragraph 5, 331, paragraph 22, and 332, paragraph 29. And as...
So are those all cases where development has taken place?
Yes. And
the application is in order to retain it?
Indeed.
So in that situation, retention and retrospectivity would go hand in hand?
Yes.
And you're deploying this, as I understand it, to show that where the development has not been retained, it isn't retrospective, the application?
Indeed.
Is that the logic?
Yes, I'm suggesting that there is a common usage of retrospective.
Well, I can quite see why it might be treated as being the same as retention, where you're actually dealing with a retained use.
Yes.
But you're seeking to move from that to a position whereby, if there isn't a use that's being retained, therefore it's not retrospective. Is that it?
Yes, right. On the basis that there isn't an authority that shows the converse.
Well, I wasn't taking issue with your point. I was just trying to make sure that I'd understood why you were deploying these cases, because they're cases where there was a retained use.
Yes, but I say that, for example, when one's looking at a side note in a bill that's coming forward and becoming the Localism Act 2011, I say that it is relevant to take into account that there is a normal and understood meaning for what retrospective means in this specific context. And that's the meaning that I suggest that it has. And that's also consistent with how it is discussed in the PPG as well. So, in terms of the overall context of the Localism 2011 changes, we spoke about the ministerial statements, and the court will have looked at those. And I don't.
How are we entitled to look at those?
I don't, as my lord knows. I say that they're not sufficiently clear and comprehensive to assist with the actual words that are used in the legislation. But I say that they are potentially part of the broader context.
We'd have to
understanding
find. Wouldn't we have to find that we couldn't construe the statute before we even started to think about whether we went behind it? We don't approach it from the other end and work out whether what's said in Parliament is clear. We work out whether we've got any right to be interrogating the affairs of Parliament at all.
And my lord, of course, we start with the words of the statute, and
Well, is it your submission that Pepper and Hart is in its modern sense satisfied or not?
No, I say Pepper and Hart is not.
No, I mean, as a matter of interest, not trying to stop you from making any submission you want, but we're not in the end going to be able to rely on what was said in Parliament.
Not if the court accepts my submission. Certainly not as to the meaning of the words, but when one looks at the way that Benyon invites an approach to these things, and some of the authorities that are before the court as well, of course one starts with the wording of the statute. To the extent that that is clear, that may provide an answer in itself, certainly by travelling around the sections that are close to section 70 and looking at the purpose of the Act overall. But there is an increasing recognition that it can be a proper element of statutory construction to look at, for example, the explanatory notes, and to look at what's identified as secondary material.
Well, I have much less difficulty with the explanatory notes. You know, what somebody said on a certain day in Parliament is an entirely different matter.
My Lord, then the explanatory notes you have, but before you...
Well, if you want to refer to those, by all means, if they help us on this.
My Lord, the explanatory notes provide, I would submit, in fact, limited assistance. They certainly don't address the issue of what the provision is intended, or how the provision is intended to operate in circumstances where there is no continuing breach of planning control. So they don't assist in that respect. Right. But in terms of the impact assessment, which is also something that the court can look at as a secondary, what I would say about that is that simply reinforces the judicial observations that are made in the cases, in any event, about the nature of the mischief that Section 70C is really concerned with. And so, on that basis, can I turn to the authorities and look in particular at the authorities of Wingrove and those following. Wingrove we have at tab 26. The first of the cases dealing with Section 70C, and we see from the head note the way that Mr. Justice Cranston approached the issue in relation to what the power was intended to address, and that's in the holding and then later on in the judgment. So page 264, about 6 lines into the holding, court will see the part of the sentence starting that the power was intended to prevent retrospective planning applications being used. And this is the key point. It's the additional precision in the mischief that arises here being used as a mechanism to delay enforcement action being taken against a development without planning approval, meaning a development that remains on the land, because the reason that the delay is a particular problem is because it's a delay whilst something that the authority has by definition concluded it's expedient to enforce against is remaining on the land. And so one sees that being discussed through the judgment, and in particular under the heading on page 269, Statutory and Planning Framework. Section 70C, paragraph 20. Midway through that paragraph, the effect of the appeal is to stop the enforcement process in its tracks, and the provision referred to. So there can be incentive to appeal, and that's something the judge expanded on in a quote in paragraph 60. There can also be an application for retrospective planning permission for the unauthorised development, which can be appealed if refused. And then he refers to Professor Purdue's article that the court will have seen, and that deals more broadly, bearing in mind constraints of time. I'm not inviting the court to turn it up now, but you will have looked at that, and it deals more broadly with the changes that were involved in the Localism Act 2011. But it's perhaps interesting to observe that Professor Purdue, as well as the editors of the Encyclopedia of Planning Law, the issue that they all alight on when they're considering what the precise mischief that was being addressed here is, that it was the point about effective enforcement and not delaying enforcement against unauthorised development. So much as my Lord identifies as a potential effect of repeated applications the use of local authority resources, that was not a feature that was identified by judicial observation or indeed by Professor Purdue or by the editors of the encyclopedia as they went through this exercise.
I'm not sure that they were contemplating a situation of the kind that exists in this case. I mean, all of the things you've taken us to so far are contemplating a situation where there's actually a building on the land which shouldn't be there. I mean, of course, in those circumstances, you're going to say, well, you can't just leave that in aspic, but while you make further applications. I mean, that's very, very clear. But that's not the situation which, I mean, they weren't thinking about this situation.
No, but it is still, I would say, relevant to observe that there is a consistency of approach in terms of identifying what the mischief of this provision is. And it's entirely right to say those judges weren't necessarily directly addressing the situation that we have here, because it hasn't happened until this case reached the High Court. Not quite in this way, anyway. But
yeah, that's Wingrove.
Yes, that's Wingrove,
Yeah.
and it doesn't take away from the more general observation about the judges trying to identify what the statutory purpose was. And so I say that what happened in Wingrove was a proper identification of the mischief and therefore of the purpose behind Section 70C. The judge, as the court will be familiar, because we've sidelined it, the discussion and the acceptance of the wide discretionary power takes place pages 272 going across to 273, paragraphs 30 to 32. And it's there just to observe that Mr. Justice Cranston identified in a phrase that has been used repeatedly in paragraph 30, since delay is the bugbear against which the section is directed, claimant's actual motives to use a retrospective planning application to delay matters are capable of being relevant. Now, as the court knows, I have suggested that there may be a more objective lens through which to see that. But that was the strength of the observation that Mr. Justice Cranston made, that the real issue that is being identified here is that of delay. And so that issue is sufficiently pressing that, in fact, it's one of those rare occasions in planning where you can look at the actual motivation of an individual in their actions. My lords, can I go to tab 28 next? That's 17 De Vere Gardens. And that was the pigeon deterrent netting case. And there, the difficulty arose because there was an administrative slip-up in the appeal process where no fee was paid, and so the Ground A appeal on the merits therefore lapsed. That was how the difficulty arose, and indeed the claim was successful in that case. But if we turn to pages 302 and 303, we can see the way that the authority dealt with the retrospective planning permission in that case. And the judge made the point that in that case, at the end of page 302, the only difference between the first application and the second application was one was complete and the other was not, due to an absence of appropriate drawings. The purpose of the provision is looked at page 304, and consistent with the approach that was taken in Wingrove, in paragraph 31 there's the reference to there being an interest in one or more parties to delay an outcome, and that is the theme of the discussion that then takes place across paragraphs 32 on the following page, and 34. And Wingrove and the essential reasoning behind that is referred to without any dissent. And at 49, a different way of characterising how Section 70C may be intended to operate. 311, 49, towards the end of that paragraph. Last sentence. In any event, this was clearly not a case where the claimant was seeking to manipulate the system. So if we think about issues of delay, issues of abuse, issues of potentially gaming the system, those are the kinds of phrases that are being repeatedly used in the context of Section 70C. And what they seek to describe is a situation where someone shouldn't be allowed to continue to try and retain unauthorised development on land. All of those sentiments, and take my lord's point about, in one sense, it's not surprising because of the circumstances in which those cases arise. But what I do say is that there is a clear theme to the way that a sequence of judges have understood the mischief behind this provision. And it is to deal with those issues.
Well, I mean, the question is surely whether the mischief that they very correctly identified as existing in the cases that were in front of them is to be taken as being the only mischief with which the provision is concerned.
Yes, my answer to that is that it's a sufficient identification of the mischief, and it is precise as well. And if one moves to a situation where it is enough to engage the mischief, that simply further applications may be made at a later point in time, or that for that reason or any other reason, there is a use of the authority's resources that would not otherwise occur. That is to broaden out the mischief in a way that goes further than is necessary for Section 70C to have its statutory object satisfied.
Surely we're concerned with what it means, not what it's necessary it means.
Yes, but in terms of looking at the purpose of the provision and ascertaining how it is meant to operate and what can be done within Section 70C and what would fall outside of Section 70C, either because of its purpose or because it simply doesn't fall within the provision at all. That is when this reasoning, I submit, is relevant.
So that's De Beer Gardens.
Yes. Banghard was a case that arose on quite different facts, where, as the judge found, there was a...
Well, speaking for myself, I don't see Banghard as a case that's actually about Section 70 directly at all, because what the judge concluded was that Section 70C didn't apply because what was contained within the application was unrelated to the enforcement notice. So I'm not sure, speaking entirely for myself, we get a lot of help from that. I mean, I'm not criticising you for citing it, of course, Mr. Bacon. You'll have to draw the court's attention to all of but unless you've got some point to demonstrate that the judge was wrong about Banghard, seems to me he was right not to actually place significant reliance on that case, because on its facts it isn't really on point.
My lord, I will respectfully agree with that. The only other element that you can take from Banghard is the consistency of the narrative that I have.
Yes, so you're entitled, it seemed to me, to say that even if it's got nothing to do with her decision, a judge who's experienced in these matters rather agreed with the previous judge's observations.
And, my lord, then I can take Chesterton, which is the next one, more swiftly, because it's essentially the same issue that arises, but just in terms of the references. 228, sorry, that's the page number of the actual report. So we're in tab 30, page 334 of the bundle. Paragraph 34 of the judgment towards the start of the section that's dealing with the statutory provisions, which starts on the previous page. And my lords can see what's said at the end of paragraph 33. So this specific and precise recognition there about the nature of the mischief, and that it's abuse of the appeals procedure because of the peculiarity that once an enforcement notice is served, there is the additional ability to pursue the
So this is
underground
an existing boathouse that shouldn't have been there.
Yes.
Right. So it's in exactly the same theme as the previous one.
My lord, it is, and that's why I try not to labour it too far, but I will just draw attention to paragraphs 36 and 37, where again the language of delay and abuse is used, because that does speak to what these statutory provisions are addressing. And then lastly, within that authority, because it goes to the same sentiments, page 342, paragraph 69, first three lines there. However one chooses to describe it, whether it's abuse, whether it's gaming the system, that is the sense of those authorities. And so against that backdrop, we turn to the O'Brien case.
What do you say to the point that's made in the end of paragraph 69 of Chesterton?
Yes.
By reference to the Smith case. It was sufficient that the opportunity to pursue an appeal against an enforcement notice had been available to the applicant's predecessor in title, even though it had not been taken and was no longer available to the applicant himself.
Yes, because that is one of the examples of abuse that can potentially arise, where someone might not take advantage of the rights that they do have to seek a determination of planning permission, and then another individual as a successor in title, or simply another applicant, as my lord indicated earlier, may make a similar application. So if you could avoid the effect of section 70C by that simple expedient of it being from a different applicant or from a successor in title, then it could be avoided in a very straightforward way.
So you would accept that, to put it compendiously, planning status travels with the land?
Yes. The other side of that coin is that shows a greater corresponding effect in section 70C, because it can be employed against successors in title, it can be employed against alternative applicants, and that makes it more important, I submit, to identify with precision the actual mischief that it is identified towards, because otherwise you have the individuals who, whilst they may know the planning history, have appropriate searches done, they will still enter onto the land, not having in any way been the individual guilty, as it were, of causing the unauthorised development to be present, potentially with wholly meritorious plans as to what should happen going forward in planning permission. And yet the authority will be able, under the construction that's being advanced by the Respondent and the Secretary of State, first of all, to simply say, well, there is an enforcement notice that predates all of this, and so the literal words of subsection 1 and subsection 2 are satisfied. And moreover, it doesn't matter that there's a successor in title and that the breach of planning control has stopped.
You also, I'm sorry, just following from my lord's question, you're also accepting, are you, that a person is taken to take the land if they're a new owner with the knowledge, the knowledge of the existence of the enforcement notice, either actual or imputed, because it's been registered?
My lord, No, for the purposes of Section 70C, I don't accept that, because there may be circumstances, and this case is one example, where whilst it was open to someone to find out about what was on the land, they may employ an advisor who may not do everything that might be expected in the circumstances.
I see. So you can buy land, not make an effective search, and then be in a better position than somebody who's been competent.
It's a factor that can go towards the exercise of discretion under the exercise of the power under Section 70C.
You don't accept what the judge said about that. Well, the judge said you take the land as you find it, because you can't expect other people, like the local authorities, bail you out if you don't make inquiries before buying land.
I'm not suggesting that issue goes towards statutory purpose or goes towards ground 2, but in relation to ground 3, it is capable of being relevant to whether or not there should be acceptance of a retrospective planning application.
Right, so for the purpose of what the statute means, it's irrelevant.
Yes.
Thank you. Sorry.
The question I was going to ask is this. You seem to be reading quite a lot into the words of Section 70C, which don't seem to be there, because the words simply seem to require there to be a pre-existing enforcement notice.
Yes.
It's fairly black and white on the wording of provision, isn't it?
Yes, and that is why it is important to look, we submit, at the Padfield lens of this, and what it is that the mischief is identified as, and therefore what the purpose of the provision is, because subsections 1 and 2 identify the gateway criteria, which is a very simple one that will be met in nearly all of these enforcement cases, where there will be a pre-existing enforcement notice in place. So in terms of the proper approach to the statute, we say that it is not a sufficient analysis to say that the baseline criteria for Section 70C being engaged is met. What needs to be considered after that is what the function is, in the same way that in Padfield the Minister had a very broad discretion as to whether or not to direct that an inquiry should take place. But the court said, and there were no words in the statute to this effect, but it's how the function test operated in that case, that if there was a substantial and genuine complaint that was being made, then in Padfield the conclusion was that in fact what the Minister had to do was akin to a duty in those circumstances. Padfield is, we would submit, a particularly strong expression of how the function of a statute can be affected or can affect the literal words. And we have a similar situation here, in as much as in Padfield the only way that the individuals who were affected by the pricing policies could hope to have their case investigated was through the investigative committee, because they would never command the consensus that was necessary to do it without there being an investigation. And so it was in those circumstances that the only way that they could achieve their object was through the Minister directing an inquiry to take place. Here, the only way that someone in Mr. Moran's position can regularise the position is to make an application for planning permission.
What might be said against you is that the context is particularly important, and in particular the role of the public interest. So in a regime of regulating the use and development of land, which is entirely impersonal and exercising the public interest, it may be said against you that the reason for Section 70C is to preserve the status quo in respect of the use and development of land, where there is already in place a definitive statement as to what is precluded. That provides not just landowners who might, or people who might be prospectively purchasing land, but the wider public, with the assurance that that is the use to which the land is going to be put.
Yes. My response to my lord is that the enforcement notice is not a definitive statement, and people who buy land nearby or are interested in that parcel of land will know that the statutory scheme provides in section 190.
But they won't necessarily know whether somebody's been badly advised about whether or not there's an enforcement notice in place. They won't necessarily know whether there's been a ground A appeal. Or well, I suppose they might if they dug around in detail in the planning register. The point is that the section, as we discussed earlier, it never says never, but it provides a break or a gateway threshold for any change in the use of land to be contemplated. And that reflects, it might be said against you, the whole structure of the enforcement regime, which is to provide clarity, certainty and reliability in respect of how land can be used and developed.
Yes, and that clarity and certainty is met by at least 2 points in these particular circumstances. The first is the knowledge that the statutory scheme contains that provision expressly for there to be retrospective planning applications that can affect the scope of an enforcement notice. And secondly, the understanding as appears from the way that the other provisions that we've looked at, like section 70A, are drafted, that planning is not, in any meaningful sense, in aspect, the circumstances that may surround planning merits are liable to change, potentially significantly, and potentially over a short period of time. So whilst an enforcement notice can provide a measure of certainty that whilst it remains in force, there will, on pain of criminal prosecution, be a need to comply with the terms of that enforcement notice. That is the essence of the remedial system. It's the point that I return to.
And the point that might be taken against you is, yes, that's the system working. It's not just criminal penalty. The local authority is entitled to go in and remove the offending development and charge the landowner for the cost of doing so. That's the system working. And what, in effect, an applicant who has an enforcement notice already in situ on their land is doing when they make a further application is effectively asking the local authority for a favour.
My lord, I wouldn't characterise it in that way. It is a fundamental right, as we looked at, in terms of how the legislation has always been drafted, for there to be appeals against enforcement notices. And one of the bases...
But we're in a world where that opportunity has existed, and for good or ill, has either been taken up and failed, or has been overlooked and not taken up.
Yes.
So we're in the world beyond the appeal against the enforcement notice, which is, I hesitate to say the first bite of the cherry, but which is, that's the world we're inhabiting. So there is an active, effective enforcement notice which preserves the use of land on pain of prosecution, as you point out, on pain of the local authority going in and clearing the land and charging the landowner for the cost of doing so. And then the landowner makes an application. It might be said against you, they can't have a high expectation that that application is going to be simply favourably or indeed received at all. Isn't that what's behind Section 70C?
My lord, no. These parts of the planning scheme proceed on the basis that, first of all, it is open, and I take my lord's point that we pass this point, but it's still important to acknowledge it, that within the enforcement provisions, there is the ability to test the planning merits under Ground A. And that has always been recognised as fundamental. And that doesn't lose any of its force in terms of its importance once an enforcement notice is in place, because the statutory scheme makes provision for, let's say, let's put some flesh on the bones. Let's say that the need for a particular kind of provision doubles in a local authority in a couple of years. And then the balance of considerations that might be very different in terms of a particular kind of provision, especially if the authority can't locate anywhere else to make the provision within an urban area, then that's the kind of example where the planning prospects could change relatively rapidly in a significant degree. And the scheme protects that because there is the ability under Section 180 to make further applications that will have the effect of reducing the scope of an enforcement notice. So that is why I submit, when Section 70C is added into this existing clear, codified and detailed scheme, that it really is attempting to deal with a very specific form of mischief. And that's the point that I've identified for my Lord's consideration, so I don't go over that ground again. What I will do, if I may, is just turn to the O'Brien case. And so if we look at tab 27, again, O'Brien was another case where it was concerned with a continuing breach of planning control. And O'Brien, in a way, shows, in a similar way to Wingrove, how the abuse can take place, because in O'Brien there are a sequence of appeals, the use of resources that my Lord has identified, and a number of dismissals of those substantive challenges on the merits before the authority decided to use Section 70C. It is in those circumstances that Mr. Justice Lewis had to consider what I would submit were really quite different questions, and the focus of the case was on the transitional provisions and whether or not the factual matrix of that case fell within the transitional provisions so that Section 70C could be relied upon in that case. And of course, he found that it could, and rejected the argument that was being advanced by Mr. Willers to contrary effect. But that is the essential context for the observations that the judge made at this section of the report that is sidelined from paragraphs 33 and then 37 onwards. And it was in paragraph 40 that the judge identified the requirement that exists in the text of Section 70C itself, that the only requirement is the temporal one, that the enforcement notice is there at that earlier point in time. And the court has my submissions in relation to that may provide the gateway, but what it doesn't answer is the point about the mischief and the purpose and the function of the provision overall. And the judge identified, using similar language to language that I used earlier, paragraph 43, what the underlying common thread in Section 123 is. The introduction of mechanisms, but it's what those mechanisms are directed towards. Mr. Justice Lewis said they're directed towards not allowing more than one test of the merits. I say that the purpose is more, and the mechanism is more specific than that in terms of what it is intended to address. And it's that point about delay where there is continuing unauthorised development. And again, this was a case involving unauthorised development, but it is worth observing the consistency that occurs even here if we look at paragraph 69 in the conclusion, for example, where the judge's approach is resting on applications for planning permission that are being made for unauthorised development there on the land. So none of these cases address directly the circumstances before this court. Where
So this case is the only one of its kind.
this case is there were some observations made in the Finnegan case in relation to my lord's point about resources.
No, I was just thinking about whether there are any other cases
No,
where there isn't a continuing
No.
breach of an enforcement notice. I mean, I'm sorry, there may very well be, but I don't have a sufficient...
Not where section 70C has been.
Right, well, by the time we finish the argument, we'll know whether there are any or aren't, but you're not aware at the moment of there being any.
So we're very clear about the issue. A case where there has been enforcement action and an enforcement notice in place, the land has then been cleared and compliance with development control achieved, and then an application to go back to back to the development in the enforcement notice and the invocation of section 70C. That I think is my lord's question.
Well, the only reason I'm pausing is that
There's some help coming from the right.
Yeah, I think we're virtually in the same place.
Yeah.
The Finnegan case
Right.
at tab 34.
34.
Yes.
Thank you.
And so one can see in paragraph 11 that was a case involving a use of a grade 2 listed building in breach of planning control. And at paragraph 11, on legal advice, the claimant ceased the unlawful use of the site before his final criminal hearing in the magistrates' court, pleaded guilty, and then, if my lords want me to address this case now, I can, or I can address it in reply, depending on the reliance or otherwise that's put on it, because it was dealing with a different approach to section 70C and relied upon the point that there could be a justification for continuing to rely on section 70C if it was obvious that the planning application that was being put in front of the authority would have the same issues as had previously arisen.
So if that's right, that speaks for it not just being limited to cases in which there's an ongoing breach.
But the reason that was important in Finnegan was because, in terms of the display of cars, which is what it was about, to display and sale of cars, the judge considered whether or not lawful conditions, as have been suggested in that case, could be imposed on the user of the land, and decided that in fact that would change the use in such a way that they couldn't be properly imposed. So it was addressing a slightly different issue about whether or not, in fact, the planning mischief could be contained in that case.
Can we just look for a moment at the words of the statute itself? I know we've all had them in our minds while you've been addressing us, but I'm looking at page 14 in my bundle. It strikes me, you may be right, but I just want to pin down in this way what your submission is. See in the third line where it says any part of the land to which a pre-existing enforcement notice relates.
Yes.
You're inviting us to read that as if it said a pre-existing outstanding enforcement notice
No.
relates.
No. I'm not suggesting that it is necessary or appropriate part of this exercise to insert words into the provision or to give it a strained construction.
No, but your previous answers said that 70C only applies if there is planning, an abnormal planning situation, namely that there's been an enforcement notice and somebody hasn't complied with it and they're trying to deal with it by making an application. That's the only situation in which you're prepared to concede the local authority can dust off 70C and exercise it.
Yes.
So it doesn't follow from that the neatest way of achieving that would be to say that Parliament intended, although it didn't say so in terms, that it's a pre-existing, outstanding or not complied with or unfulfilled or whatever word one might like to use, that it's an enforcement notice which has not been acted on. That's your case on statutory construction.
Yes, but the way that I get there is by a different route than
But
by...
you get there by pointing to a statutory mischief which has not been written down anywhere, just by a different form of construction. But I mean, the simplest way to achieve it would be to say that there's a silent word in there which says outstanding enforcement notice.
Yes.
That's what Parliament, according to you, meant.
It could be done in that way, but the route that I invite the court to adopt, in the same way that was done in Padfield, is to look at what the purpose of...
Well, I know, but it's same difference, isn't it? I mean, I appreciate you shy away from putting words into statutes, but that's the effect of your submission.
I think you have a further submission based on the heading in the section, don't you?
Yes.
Because you say where the section is described as being a power to decline to determine retrospective applications, that you submit, I think, because we looked at what retrospective might mean earlier, suggests that the section should be construed on the basis that there is a non-compliance with the enforcement notice.
Yes.
Because retrospective, on your case, means retention.
Indeed.
Yes, well, it seems to me we're talking about the same thing. It can be achieved in a number of different ways.
Yeah.
Yes, it can. But in answer to my Lord's point about retrospective appearing in the side note, of course, the guidance is that those are secondary indications, but equally they are capable of being material. And this is not a case, as for example the business interest development case, where the side note is in any way inconsistent with the purpose of the statute or what it might have been seeking to achieve. So it is capable of being a guide to the use of that provision, to illuminating what the mischief is and what the solution may be. So I say that the presence of the word retrospective is relevant for those reasons.
And how do you square that with the reference in subsection 1.2, permission in principle?
My Lord, in relation to permission in principle, retrospective was present in the bill as it was passing through Parliament. It was part of the 2011 Localism Act and adopted on that basis. The amendments in relation to permission in principle occur as a result of the 2016 Act, and they are inserted into various provisions so that there is a consistency in how permissions in principle are to be treated. That does not discount from the force that can be given to the enactment in 2011 of those provisions with the side note retrospective.
Is that the cases?
my lord, on grounds.
Sorry, can I pursue my question? Because I'm not sure I've quite understood your answer to the question I was asking. I mean, I take your point, of course. The words to which I was drawing attention come in later in 2016. But if Parliament understood retrospective application in the way that you suggest, what business did it have in inserting permission in principle in 2016? Because on the face of it, that's inconsistent with that understanding.
Well, there may be a measure of inconsistency there, but what I say is that by the time, the appropriate stage at which to judge the mischief and what is being addressed by the provision is as it passes through Parliament and as at the date of enactment of the bill.
To be sure, but my Lord Justice Dove's question was about your ground 2, and that's my question. My question is directed to as well.
Yes, I would say that the same essential logic applies in circumstances where, at the point of enactment, what was under consideration was whether or not this provision ought only to apply to unauthorised development that was on the land at the time, or whether it should be prospective in its effect. And the insertion of permission in principle is consistent with Parliament simply wanting to ensure that there was a coherence of treatment in how permission in principle was being dealt with, so that it was capable of being addressed by Section 70C as well as by the other sections where it arises. It is not a sufficient indicator, I say, to negative what the intention should be taken to be in 2011. And there is nothing in that I am aware of in the explanatory notes to the 2016 Act or otherwise that would suggest that that was an important part of why permission in principle was inserted into Section 70C. Well, then finally, can I turn to ground 3? And for these purposes, can I invite my Lord's attention back to the core bundle and the officer report starts at page 155.
Is that the electronic numbers or the?
My Lord, that's not the electronic numbers, I'm afraid. About 60 pages on, I would imagine.
Okay. See how good my maths is. Turns out it's not too bad, actually.
So, my Lord, the report here setting out the proposal, acknowledging what the submissions contain, the planning support statement, landscape and visual appraisal, landscape policy assessment, preliminary ecological appraisal, and then setting out the planning history, looking at the application of Section 70C against the legislative background, and the section is set out. And then under the assessment, we have the conclusion, which I don't challenge, that current proposals, this is on page 158, current proposals overlap, and then the reasons for that are identified. Continues, the application form states that the work or change of use has not already started, with the planning support statement saying that the applicants purchased their plot unaware of the enforcement notice. So in ground 3, I say that that's something that the authority can take into account, and they did acknowledge in the report. And then later on in that paragraph, further they say, with the notice effectively complied with, the applicants now wish to make a fresh planning application for their own and 3 other pitches on the site. Next paragraph down, reference to the site subject to the enforcement notice having been cleared as a result of direct action. And then the conclusion on criteria on the following page after some reference to the local plan. Some of the matters for which planning permission is sought are matters which are specified as valid pre-existing enforcement notices. Criteria for the engagement of Section 70C are satisfied. So that's the basis upon which the authority then continues to proceed, and it looks at the exercise of the discretion and says Section 70C was introduced to ensure the time taken to determine a planning application, including appeals, should not prevent effective enforcement. So pausing there, again, I say this is the planning officer rather than parliamentary draftsman or anyone else identifying the test. But that's the test that the authority have identified for themselves to test the exercise of the discretionary power. And in those circumstances, that's the question that is never answered in this report. And I submit that if my lords are against me on grounds 1 and 2, then the importance of this question to ground 3 becomes all the more important, because it is right to look, as the authority did, is there something that is a delay or an abuse or gaming the system? They pose that question for themselves, but it's not answered in this report. So I say that's an error of law, and that's one example, mandatory consideration that they needed to take into account in their assessment, especially bearing in mind the fact that they acknowledged the additional materials that have been provided, again, later on in that sentence. On page 160, they refer as another feature that we will see was ultimately critical to their approach, the Environment Agency flood map for planning, and they said it showed the site as being in flood zone 3. As the court will know, the materials that were supplied with the planning application included an excerpt from the flood map showing that this land was in fact in flood zone 1. And so that was a simple error as far as the updated mapping of the local situation was concerned.
What do you say about the last paragraph on 159 or 219 electronic?
The paragraph starting unallocated site.
The site, which is an unallocated site.
Yes.
It's wholly unsuitable.
Yes. Can I move to that almost immediately, Mark?
Yes.
So as we look at what happened in relation to the flood zone, and then we go on to the analysis of the other policies that the authority was concerned to apply at the foot of page 160, and then it moves towards their conclusions under this likelihood of success analysis. And then in that last paragraph, this is said, current submissions include, and then those are set out, but it is not considered they overcome all the fundamental concerns. So this is the officer recognising that there is a degree to which previous reservations about the planning merits had been overcome. But it's not explicit the extent to which that has happened, but it may be sufficiently implicit from what follows. This includes recognition that there was a local landscape designation called an alley designation, and as my lords will know, approaches to local landscape designations have varied over time. That was an old one contained in a very old local plan. Has limited weight in reaching a decision. It would be possible to enhance biodiversity, so that was recognised, bearing in mind the neglected state of the land and significant disturbance caused by previous unauthorised development. Now, the three features that are then identified appear to be crucial in the authority being able to come to a conclusion that there are sufficient remaining concerns. The first is rural location. The second is harm to character and appearance of the surroundings. And the third is unacceptability with regard to flood risk. So those are the three features. This application had a clear answer to each of them. First, in relation to the rural location, the policy guidance, which is not referred to anywhere in this report at national level in PPTS, is to recognise that there may well be circumstances where it is appropriate to have provision for the gypsy and travelling population outside of the urban area. So that's specifically in national policy that was not referred to at any stage in this report. And part of the reason, critical reason for accepting that, is based on the level of need locally and the potential availability of sites. Now, this report refers to the GTAA, but it never acknowledges the serious extent of the need that was set out in the GTAA, and it doesn't suggest, and my lords may know this from experience, it doesn't suggest that there is any way that that need could be accommodated within either allocations that are coming forward, whether it's part of a housing allocation or its own allocation, or otherwise within the urban area.
Sorry, this is the issue that's been dealt with at 221, isn't it, or 2161, or whatever it is?
Yes. The 3 points that the authority appears to continue to
the point that you were
place
dealing with, which was to do with the consideration that ought to be given to gypsy or traveller
yes.
applications, is under likelihood of success on page 161.
Yes.
So I'm just looking at that paragraph there. What is the shortcoming of that treatment of this issue?
The shortcoming is in relation to the suggestion, as part of the linchpin of this decision making, that there are 3 factors that they can rely upon. First is the rural location. I've addressed my lords as to that.
I understood what the 3 factors are, but you went on to say that they didn't turn their minds, or however you put it, satisfactorily address the status of your client as being entitled to particular consideration as a traveller.
Well, no, I don't make that.
Right. So can you just, now that I've got it in front of me,
Yes.
could you just explain what's wrong with the way in which that issue was addressed?
Yes. So the GTAA, which contains the assessment of need
Yes.
locally for the provision, was identified as a document, but there is no reference to what was, on any view, just a significant level of need within that document.
But the paragraph that refers to the document, which I think we now have as tab 40, we don't need to go to it, but it's acknowledging shortfall in the number of sites. It says that the assessment is going on and still underway. What's wrong with that?
When one comes to look at issues of housing need and supply, whether it's for conventional housing or whether it's for the travelling community, it is critical for planners to look at the nature and extent of the shortfall that may exist. There is recognition of the GTAA here, but there is no recognition of the fact that for the period 2017 to 2035, there was an identified need within the GTAA for 34 additional pitches. So a significant level of provision that needed to be made. Twinned with that, within this report, there is no identification whatsoever as to how that can be accommodated without the use of rural locations. So that's the force of this point, that the authority is saying one of the 3 things that we think really stands in the way of this proposal is its rural location. And on the face of it, it's outside of a settlement boundary. But national policy identifies the fact that it may well be necessary for members of the travelling community to have provision made for them outside of settlement boundaries. And here there was a significant level of need and no solution identified. So that fundamentally undercuts
Well, the conclusion was that the special factors, which went beyond the one we've just been considering, page 222 in electronic binding, 162, it seemed unlikely that any of the factors would be sufficient to outweigh the harm and breach of policy represented by the proposed development. What is the submission that that wasn't a conclusion that was open to the officer?
Yes, because of the logic that's contained in page 161. Because rural location, I've addressed. Flood risk, I've addressed in terms of it simply got that wrong. And second, in relation to the character and appearance of its surroundings, there is no attempt, as far as one can see from this officer report, to engage with what were the detailed analysis and conclusions of material that they hadn't had before in relation to the landscape and visual appraisal, with the potential for landscaping and reaching a conclusion that this could be accommodated within the landscape without significant harm. So that was something, but bearing in mind these are the three factors that appear to be being relied on. It's not that one of them has a difficulty, which I would say would be sufficient to send the matter back to the authority for reconsideration. All three of them have a logical problem of the kind that does entitle this court to intervene. And so it's because the ultimate conclusions in relation to the discretionary power are based on those difficulties that infects the ultimate conclusion, and I say is sufficient to entitle this court to intervene, and so that this matter should be sent back to the authorities so that they can consider, for example, whether or not, bearing in mind that the breach of planning control has ceased for an extended period of time, there is no issue in relation to enforcement delay, whether or not this is a case where they ought to consider whether or not planning permission should be granted.
That's been very helpful, Mr. Begum. Thank
Grateful,
you.
my Lord.
Yes, Mr. Neal.
Lord, I'm grateful. Just looking at the clock and conscious of your Lordship's indication that you
Well,
be
we have,
helpful
we
if we
have,
finish
we have lots of time.
Yes, I think what I'll try and do is get through the interpretive point and the question of whether or not this section applies at all to this particular circumstance, and then deal with purpose. And then that may be a point where I pause and deal with the
That's
material
helpful. So
consideration.
let's see how,
That's
let's
how
see
I
how you
propose
go.
to take it.
Thank you.
So, in light of what we've heard this morning from my learned friend, it seems that the question about interpretation looms large, because without that, of course, without that question being answered, one cannot really ascertain what the purpose of the provision is. And it was for that reason that in my skeleton argument I addressed that submission first of all. What I thought would be helpful is just to start from first principles when it comes to the question of interpretation of this provision. And although this may well be, this ought to be uncontroversial, the starting point is, of course, that when looking at the meaning of Section 70C, and indeed Section 123 of the Localism Act, the task for this court, as a matter of statutory interpretation, is an exercise to identify the meaning of the words born in context. And I emphasise that it's the meaning of the words. The task of this court is to ascertain intention, of course, but that is the intention which the court reasonably imputes to Parliament in respect of the language used. And it may be helpful if I just pull up the case of Katie, and that's at tab 36.
Sorry, tab.
Tab 36 of the authorities bundle.
Thank you.
And it's my page 502. And there's a helpful analysis by Lord Justice Singh there of the purposes approach to statutory interpretation.
So which paragraph?
And I'm looking at paragraph 118, bottom of page 502. And there we have a reminder of what the approach to statutory interpretation entails, and this is derived from the case of Spath Home. And there we have it set out that statutory interpretation is an exercise which requires the court to identify the meaning brought by the words in question in the particular context. And the task of this court is to ascertain the intention of Parliament, expressed in language under consideration. This is correct, may be helpful, so long as it's remembered that the intention of the Parliament is an objective concept, not subjective. So that proposition, don't think it's controversial. That is the exercise that the court is undertaking when looking at ground 2, or in my issue 1. The second observation in terms of principle I'd just like to draw your Lordship's attention to is that it was in some way suggested that in undertaking that exercise, one should have regard to the regulatory impact assessment. Now, we didn't go to that particular document. My learned friend didn't take you there. But whilst it was sort of mentioned in the same breath as the explanatory notes, and just like in terms of first principles, I take no issue with the relevance of the explanatory notes being referred to. As it happens, my learned friend didn't seek to draw any conclusions from that. But in terms of the regulatory impact assessment, in my submission, more care should be taken when having regard to that, when looking at the interpretation, specifically when looking at the interpretation of this provision.
Well, we weren't taken to that either.
We weren't taken to it. I just wanted to it wasn't quite clear to me whether or not the learned friend was trying to draw any conclusions from it. But in my submission, it is extremely doubtful whether it is even an admissible tool to statutory interpretation. But because my learned friend's not relying on it, I'm not going to go there. What I would say in terms of the explanatory notes is that there's nothing that assists one way or the other in terms of the meaning of section 123. So looking in particular at the interpretation of section 70C, I have, in essence, seven points, but perhaps if the Cheston point isn't be taken, 6. I'd just like to take these in order. My primary submission is that section 70C, and in particular the conditions that it sets out as to its applicability, are clear and unambiguous on the face of it. It doesn't say that it only applies to section 73A applications. It doesn't say that it only applies in circumstances where there is a delay, or that the authority considers that the only reason the application has been submitted is to create delay in the enforcement process. And it certainly doesn't include, I think, the way my learned friend puts it, it certainly doesn't include any condition that says it only applies if there's a continuing breach of an enforcement notice. And that is, as your lordship's identified with in discussion with my own friend, that is what the appellant, that is the construction that the appellant is seeking to advance before this court. So that's my first point. On the plain and ordinary meaning of the words of section 70C, there are no further limits to the applicability of the power other than those actually set out in section 70C. Now that ought to be, were it not for the heading, that would be the end of the matter in terms of the statutory interpretation point. What my learned friend is doing, and you've seen, your lordships would have seen the way this point has progressed. It wasn't a point raised in the High Court. I don't take a point about that now. But it was, however, canvassed, and I certainly before Mr. Justice Carr, this point was raised because it was an obvious one, because one saw the term in the heading, retrospective, and therefore the judge was certainly addressed.
So you're not resisting the grants of permission to appeal on this?
I'm not resisting that. It is, I've made that clear in my skeleton. It was raised by me before the judge, and the judge and Judge Below and the judge grappled with it and say there's no reason why this court, it's a point of law and there's no reason why this court ought not to, equally ought not to address it. So in essence, my learned friend's case is, well, on the plain meaning of an ordinary meaning of the words of section 70C, it doesn't apply to section 73A. But in essence, because of the heading, he's praying in aid the heading to say, well, that means you can construe the meanings of the section as only applying to retrospective applications. Now, in my submission, that approach is wrong. There is clear authority, and I'll take your lordships to that in a moment, that the headings, just as, the same way as side notes, do not and cannot override the language in the provision itself. And there's also clear authority that headings, clear caution has to be attached to the use of headings because they may not be entirely accurate.
You've given us the...
And I've given you the references that you have the case of McGrath, that makes the point about overriding, and also tab 46 in Benyon, that is academic authority at least for the need for caution to be exercised with headings because they may not be entirely accurate. Now, in terms of with that in mind and with that caution in mind, I make two principal submissions about the use of the term retrospective in the heading of section 123 and section 70C. My first submission is that the meaning of the word retrospective, as it appears in the heading, is not confined to section 73 applications. And I don't think my learned friend and I disagree that one often, certainly in planning world, often uses or describes section 73 applications as a shorthand, or describes them by way of shorthand as retrospective applications. But there's nothing that, and this was, I don't think my learned friend's been able to point to it, there's nothing in the Town and Country Planning Act that actually defines the term retrospective. So it only appears in this heading. And my primary submission is that the judge below was entirely right in his observation at paragraph 115 that the use of that term is merely a reflection that the development here seeks to authorize development that was in the past unauthorized by the enforcement notice. So, or put in another way, the application looks looks back, if one looks at the word retrospective has that connotes looking back, the application looks back in the sense of seeking permission for something that's already in the past covered by enforcement notice. And Malone Friend didn't hear any submissions this morning as to why that interpretation by the court below was wrong. In my submission, it was entirely correct. That in other words, the term retrospective is broader than merely a Section 73A application. Now, even if I'm wrong about that, and the term retrospective is confined to, in the heading, is confined to meaning only Section 73 applications, in my submission, then that is solely an acknowledgement by the draftsman that, of course, Section 73 applications are likely to be the most or are the most likely scenario in which this power is engaged, but it's not precluding others. So we know it doesn't preclude others because we now have, for instance, permissions in principle being covered by this provision, a point that Malone and Friend will no doubt Mr. Streeton has made in his submissions, and these submissions I entirely endorse. And so all of that is consistent with the Council's interpretation of Section 70C, and in particular that heading, that it doesn't change the meaning of the words, the actual operative meaning of the words of the section. And it neither means Section 73 applications, and even if it does, it's not seeking to limit the actual operative words of the section. Now, Malone and Friend also made reference to Section 70A. I think this was in the context of the interpretive point, and was saying, well, actually, you have you can have subsequent applications or repeat applications dealt with, or the mischief there dealt with through Section 70A. Now, I didn't understand that to be a point relevant to the actual construction of Section 70C. And I'm going to leave that when we come to looking at the statutory purpose. But just in case that is being advanced in some way, it's relevant to the interpretation of Section 70C. 70A is a self-standing provision. It was enacted prior to Section 70C, and it doesn't deal with the circumstances here. So it's a very limited assistance in my submission in actually understanding what the meaning of Section 70C is. Section 70C is. So, in terms of, I've already mentioned the regulatory impact assessment, not admissible aid to interpretation, not assisted in event. I'm not going to repeat that. My final submission on the meaning of Section 70C is that there's no reason why, even if it's correct that the purpose of the provision is to prevent delay, so let's assume Malone and Friend is correct about the purpose, there's no reason why in those instances it should still only be limited to Section 73 applications. And this is a fairly fundamental point because it goes to the precise circumstances here where we have a site that has been cleared. There has been no compliance by anyone on the site. All that's happened is the council has come in and exercised its direct action rights to do it. So there was repeated reference that there's been full compliance.
In fact, the council spent £100,000 or thereabouts
indeed
clearing the site.
But I don't take that point isn't actually relevant to interpretation. It's just that it's something that Malone Friend raised repeatedly, that there's been full compliance. That's actually wrong. The council has exercised its direct action rights to clear the site. But the reason why
So the correct interpretation is that as you would put it, the enforcement notice was not complied with, but the nuisance or whatever you call it was not continuing because the council stepped in.
Indeed, and that is exactly the situation that applies. Now, why should it be in those circumstances? Why is it that the council says, well, Section 70C should still apply? And this goes that if my learned friend is correct, that the purpose is to prevent delay. Well, that's because in this scenario that has occurred now, there's nothing to stop the appellant or any other unscrupulous landowner from waiting for the council to come along, clearing the site, submitting a further application, and then appealing that, and that in itself, in my submission and set out in my skeleton, would in itself hold up direct action being taken. It would be a factor that would be used, for example, to injunct the council, because it would be said there is a valid application having to be being actively considered by the council. And
so just stepping back a stage, you're addressing here the submission that 70C applies where there is a non-complied with enforcement notice. And so the point that you're making is that the employment notice was in fact, if this were to be the test, uncomplied with, and it would have remained uncomplied with unless the council itself had stepped in. I mean, let's suppose the council didn't have the money or time or inclination to clear the site. It would have continued for a longer period, and so on the appellant's analysis, they would have been in difficulty under resisting Section 70C merely on the basis that the council had or had not taken action.
yes, indeed, I think the point really, and this goes to interpretation. It creates an absurd result, because if the limitation that Malone and Friend wants to impose on the operation of Section 70C applies, then it means that an appellant or a landowner is merely by waiting for the council to take direct action and to remove the breach through its own actions is placed in a better position, because it means that landowner.
Yes, and conversely, the council is placed in a worse position.
Indeed.
By spending hundreds of thousands of pounds or whatever it is to clear the place up.
Indeed, but the point, the most important point that Malone and Friend hasn't addressed is that there would still be delay to enforcement in the wider sense of the term, because of course direct action isn't actually one of the defined enforcement action.
So, I mean, the general point is that the interpretation against which you're arguing, putting it in a particular way, if that was the correct interpretation, it would have capricious results depending upon how either the occupier or the council responded.
Indeed, and it puts. I mean, this is the submission I've made at paragraph 18.7 of my skeleton. That merely because the site has been cleared, whether by direct action or by the recipient of enforcement notice complying with it, shouldn't entitle an applicant to have a fresh opportunity to have the merits considered in those circumstances. And that there is the mere fact that the site has been cleared doesn't mean that there's not going to be a delay down the line as a result of a further application being submitted. There's nothing to stop an appellant putting an application in, reinstating the unlawful development, and then relying on that relying on the extant planning application to create delay. So that the submission delay could never occur through allowing this application to continue. This may be it may be theoretical, but there still is that risk of delay, regardless of whether or not, as at today's date or at the date of the judgment, the unlawful development is actually present on or ongoing at the site.
Isn't the purpose of all of the statutory provisions in relation to enforcement to ensure that there is no breach of development control? So once in the public interest, a breach of development control has been remedied. In fact, whether or not the council have had to step in and do it themselves, isn't it pertinent for the schemes of the legislation to put in place, if not an absolute brick wall, certainly an obstacle in the way of seeking to go back to that which in the public interest has been extinguished as a breach of development control?
Yes, and Section 70C imposes that additional hurdle because one would have to demonstrate that there has been a material change in circumstance.
Well, that's then a secondary question, which is not necessarily addressed until one gets to ground 3, which is to say, well, what is the threshold? But I speaking entirely for myself, I wonder whether you're trying to prove too much.
Well, that may be the case, but it's this is the way the submissions were put in the High Court. It's in essence what the judge below accepted, that risk of further delay, even if the development was not actually, or the unlawful development at the time was not ongoing. There could still be that risk further down the line. And that reflects broadly, as your Lordship's indicated, the public interest in ensuring that the planning system or the enforcement regime is adhered to. There's nothing inconsistent with that point, with that proposition. So that is all. I think it's all set out. It's set out in my skeleton. If one looks at the meaning of the words and looks at the provisions, there is a in my submission a complete set of conditions that Parliament has intended to be or has set out in order for the power to be complied with. And my learned friend is trying to write in, frankly, words that the meaning of which shouldn't be written in on the face of the provisions themselves. If Parliament had wanted to say to impose further limits on the exercise of the power, it could easily have done so in the ways that I've already indicated. It could have quite easily said this should only apply to Section 73 applications, or that this can only apply in cases of clear evidence of delay, or that it should only apply to where there is an ongoing breach of planning control. And it does none of those three things. Well, the words on the face of Section 73 contains none of those three points. So, moving to the question of purpose.
How are we doing with your 6 or 7 points?
Those were my.
Right.
I've got to.
It doesn't matter. We don't have to.
I haven't numbered them.
But they're all in there.
Yes, they're all in there.
Fine. Don't try and.
No, I'm not going to try. The only other point was the Chesterton point, i.e., that the Section 73 or Section 70C is not limited to to applicants, but it also applies to predecessors in title, where they had the opportunity. I didn't understand my learned friend to be saying that there is that, or that Section 70C should be interpreted as only applying. I think he accepted that point. So I'm not going to. I don't need to address your lordships further on that. So turning briefly to the Padfield ground of challenge, the ground one, appellant's ground one. The starting point again, when one looks at sort of first principles, that this is again a matter of statutory interpretation first and foremost, and that when one is looking to identify the purpose of a provision, one is looking to give effect to the objective intention of Parliament, and that is ultimately a matter of construction. And again, I'm not going to take your lordship to it because I can give you the reference, but that's Spath Home, tab 22, page 208 of the bundle. That makes it very clear that the policy and objects of the Act must be determined by construing the Act. Now, I've also relied my skeleton on the Palestine case, tab 32. That makes it clear that one can have more than one statutory objective, and that there doesn't have to only be one purpose of the provision. Yes, that's
I've got tab 32.
Tab 32, page
It's 360.
360, I think.
Yes, it is. But I was thinking more.
So that's
where
where
within the authority.
Yes. Grateful 381. Yes, so halfway back down the page, paragraph 65. There, the court observed, Supreme Court observed, citing the Monsell and Ollings, that a statute may well have more than one statutory objective. You can see that 6 lines down on paragraph 65.
Thank you.
And you'll see the reference I've already given you to Spath Home. That's again repeated at the bottom of that page just for ease of reference. The paragraph 68, the overriding aim of the court must always be to give effect to the intention of Parliament as expressed in the words used. Now, I think my learned friend and I agree, and there's no difference between us, that an appropriate method of construction is to look at the legal mischief that an enactment seeks to remedy. And just for the sake of, if one turns to tab 44, this is Benyon, page, I think 612, it's very small on my printed out version.
612.
612, it's internal page 448. I think it's electronic page 612, tab 44.
Yeah.
And there
Meaning of mischief.
It's entitled Mischief, and you have at the top of the page, reason for passing an act is almost invariably to change the existing law so as to remedy a perceived defect in it. That defect is the mischief to which the act is directed. And I'd just like to draw your lordship's attention to the following paragraph. The mischief 12.6, subsection 1, the mischief that the legislature intends an enactment to remedy may be either a social mischief, which is coupled with a legal mischief, or purely a legal mischief. And then one sees in subsection 3, the legal mischief is a condition which constitutes a defect in the law or is regarded by the legislature as constituting such a defect. And what should I just for the sake of over the page, 613, 5 paragraphs down. I don't think this is controversial, but the purpose that there, it's stated that the purpose is to provide a remedy for the mischief, and I think there's no difference between my learned friend and I that is, when one's looking at purpose, that is what you're looking for. The purpose is to provide a remedy for the mischief. Where we do disagree is what the mischief is. Now, in my submission, the right approach to identifying mischief was the approach taken by Mr. Justice Lewis, as he then was, in O'Brien. And he was looking precisely at this question of what is the legal mischief in the pre-existing legislation. Effectively, is there a gap? And again, it hasn't been really made particularly clear in my submission by my learned friend how Mr. Justice Lewis, as he then was, analysis is actually wrong about the identification of that legal mischief. In my submission, the legal mischief was the existence of prior to the enactment of Section 123, the existence of the double opportunity to have two separate considerations of the planning merits. There was nothing to prevent that in the pre-existing statutory framework. And Mr. Justice Lewis was quite correct in identifying that as the mischief that was being sought to remedy, that this Section 123 was seeking to remedy. The Council's primary submission is the purpose of Section 73 is to remove from applicants, and this is an important qualification which moves on slightly from Mr. Justice Lewis's formulation, or importantly, successors in title. So the purpose of Section 73 is to remove from applicants or successors in title the opportunity to have the planning merits in question determined more than once. And that's set out in my skeleton at paragraph 3. And it is the effect of Section 70C that removes the potential that double opportunity creates of delaying enforcement. I can't deny that. Of course, its effect has that. Of course, the effect of the provision has that effect. It does remove the potential of delay. But that isn't its ultimate purpose.
Well, it may have a number of effects.
Indeed. And it may have another effect has been identified. It's not something relied on by the Council, but it's identified by the Secretary of State, that it reduces the administrative burden on authorities. It also has the effect.
So you don't rely on that?
I haven't advanced any submissions about administrative burden. That didn't form part of.
Why not? I mean, if you're
I certainly adopt.
If your ratepayers have a certain amount of money that has got to be spent on a certain number of projects. I mean, it may not be the biggest point in the world, but I mean, why should resources, if it's repetitious, and in some cases abusive, why should resources be devoted to going back over the same question again and again?
Absolutely, and that, but in my submission, that in terms of the purpose. Is still my primary submission is the purpose is to remove that opportunity of having two considerations of the merits. Now, the alighting or relieving the administrative burden is one effect, and it's certainly a beneficial effect.
Another effect may be the protection of the public's investment in clearing the land to ensure compliance with the enforcement notice.
Absolutely, these are all beneficial. Could be said to be beneficial effects, but in my submission, one has to look quite carefully at the purpose.
No, I have your submission in that context.
So I'm not going as.
But the point is, you may identify a mischief as you describe it, but the correction of the mischief may not be confined to having a single beneficial impact. There may be a variety of beneficial impacts of that mischief being solved, providing in and of themselves a variety of motives for the legislature to seek to correct the mischief.
Absolutely, and one of which is, of course, the point my learned friend is trying to construe as the purpose. One of those benefits, again, is prevention of delay. And I don't deny that that would be an effect of the removal of this double opportunity. Of course it would. But that doesn't change the underlying statutory purpose, which I've already identified. My learned friend's taken you to Mr. Justice Lewis' analysis in O'Brien. I'm not going to go over that. Your lordships can read that.
Can I just go back to your formulation of your core submission as to what the purpose is? There are only one look at the merits. Is that? I mean, one might say that 70A had the effect that you weren't allowed to have another look at the merits within 2 years.
Yes. So
that's to prevent simply reflex applications. As soon as one is refused, another one is issued. To what extent does your formulation take account of the distinctive feature of C, which is that there is in existence an enforcement notice?
I think Section 70C does take that. The formulation of, or my formulation of the purpose does take that into account, because it references the opportunity to have the planning merits in question determined, not just the fact that an application has been submitted. And I think that, so it's going further than Section 70A, which merely says if you've had repeat applications, the authority can...
C has either the disadvantage or the advantage, depending upon your perspective, over A, that it doesn't have a 2-year threshold.
Indeed, it's a less generous provision vis-a-vis a developer, because it's easier for the conditions to be met.
Right. It doesn't mean that you can act more quickly. It means that you're not bound by. You can use it against later applications.
Yes, there's no time bar, and therefore, and that reflects the fact that we are in an enforcement situation. An enforcement notice has been served. It remains on the register, so it makes sense that there is no time bar. So the purpose that I've...
Is there any other feature that C has that A doesn't have? Because I think the case that's being made is, if you've got a good case against the application, you can not consider it under A. But you're saying that C goes on longer.
Well, C goes on longer because there's a condition that it has to an application.
Yes, but the further submission might be that if you could go under A, you shouldn't go under C.
Yes, and that is, so Section 70C is doing something further that Section 70A it isn't. It's providing an authority with a greater discretion or greater opportunity to decline to terminate an application.
Well, Section 70A, one of the criteria is that there has been either an appeal dismissed or an application refused, and that's a distinct set of circumstances from the service of an enforcement notice, because the enforcement notice is in the context of the scheme for enforcing against breaches of development control, whereas Section 70A is directed towards the other side of that coin, namely obtaining permission for planning permission.
Indeed, and that is why I emphasise this point about the opportunity to be taken, because if the interpretation advanced by the council that I'm suggesting is correct, Section 70C removes that opportunity. Whereas in Section 70A, one has to have applied, refused, and there are these other conditions.
That's another form of distinction.
Although there is a consonance in relation to the bites of the cherry simile, isn't there? Because what Section 70A is saying is you've had one bite of the cherry, you came second, and you now can't within 2 years have another bite of that cherry.
Indeed, and Section 70C is actually, it's a bit of a misnomer to say it's prevent 2 bites of cherry. It's to, and I think it's set out in O'Brien, I think, but it's also to prevent situations where the cherry is dangled but not actually bitten.
Yeah, the point that my lord was making earlier about, well, what about if you haven't taken up your right of appeal?
Indeed.
Yeah.
So that Section 70C does have a role to play, notwithstanding 70A, for the reasons we've just discussed.
Okay, well, would that be? I mean, I think we're well up on time, aren't we?
Yes, and that's. That's a convenient moment for me to pause. If
Yes,
that
well,
was
I mean, make a final good point in relation to interpretation when we come back. But you can. We'll start again at 2:05. Thanks very much.
All rise if able.